We have a lease that he drafted with two conflicting provisions. The 30-day provision is a part of that standard lease boilerplate. That 60-day notice provision was written in very intentionally subsequently. We have the authority to say this is a mistake in the agreement. Or is it simply a bit of confusion that we must necessarily interpret against him? And I couple that with something that you started to go to, Patricia. She actually gave him 60-day notice. I think later on, she said, you know what, there's a confusion and the law says I only have to do 30. So is there also an argument to be made on his behalf that she believed it was 60 days, acted as if it was 60 days, and he reasonably relied on her 60-day
I have something that clear that up, because in these text messages, the tenant writes, Barry is raising rent for the room, so Milan is no longer interested, and I'm going to repost. Don't want people getting confused on price, who to reach out to. Then the answer is yes, I will go ahead and delete them, but I need to understand what that means for me because I don't want to be financially responsible for the increase in rent. She writes back to the other tenant, you're not. You're paying until your lease ends October 15th or whenever your 30 days began. You won't be responsible for anything. Right. So it's pretty clear that he really did intend to raise the rent. Whether he did in the end or not, she gave 30 days. He did not mitigate because they did have a tenant. And so I think based on that, we might be able to find
And I think we can reconcile the two differences because there are two aspects to the notice. Number one, when I'm actually leaving.
Correct.
Number two, when I'm going to be responsible for rent. The second provision doesn't indicate any responsibility other than notice, which is fine, and she gave the 60-day notice.
So I do think, Michael, that you made a good point. I mean, there's a way to reconcile both, but at the end of the day, maybe we're just working too hard because he wrote a bad lease. Yeah. So good. He loses.
Good. I think for all those reasons, I'm willing to give her back her money.
We're unanimous, 1,050?
Yes.
Very good. Thank you. So this was interesting, and it was mostly interesting, Mr. Egbali, because your lease is a mess. When a lease is this confusing, where one provision says one thing and the other provision says another thing, the law is really clear. The person who wrote the confusing lease is the loser, which means that you have prevailed. The judgment will be in your favor for $1,050 for the return of your security deposit. Very good case you made. Good luck to you both.
Thank you, Your Honor.
Court is adjourned.
I was upset. I was confused.
It is an arrangement that's been for the last several years between those roommates.
So I said the best way to do it is take it to court and see what the judges have to say about it.
I make sure that it's more solid.
Yeah, I think he should definitely get somebody else to rewrite the contract.